for joining the Real Planning Podcast. It's where real estate and estate planning converge. And here today in the studio, we're with attorney Martha Prizio and attorney Morgan Jones to talk about the buyouts between maybe siblings, different folks that own title, own real estate together, and where one might want to remain as an owner of the property, but another wants out. So let's talk about the different aspects of a buyout scenario.
Thank you, Jackie. So Martha, we get these questions a lot of I own property with my brother, say, and I want to refinance this and have him come off of title. What are some questions that we need to ask to figure out what we're doing here?
I would say the number one question that both consumers and lenders have is, how do we structure this deal? Is this a refinance or is this a sale transaction? I think most people, when they indicate that they're wanting to do a buyout, they think of it as a refinance. And what we have to remember is the refinance option is really only going to be available where the individual that's actually refinancing to buy the other person out, that person already has an ownership interest in the property.
That makes sense.
So it might also come into play, say for example, if two siblings inherit a property and one just lives far away in California, they're not going to use the property, or maybe they just can't afford to pay for their share of the property. So the sibling that has an interest in keeping the property will buy the other sibling out.
That's exactly right. And so in that very important scenario, there's actually two subsets of that. One whereby the siblings have already inherited the property. The estate is closed. Transfer has passed by virtue of probate or inheritance to the individuals, and they actually own the property. In that case, that's very straightforward. You can treat that as a refinance where one individual pays to have the other individual come off title. But what we frequently see in the case of inheritance is that title has not yet passed. So title is really still in an active estate, and title has not yet passed to the heirs of that estate. And in that case, we really are talking about a future interest that the beneficiaries, the heirs, have in the property. And so ultimately, that needs to be treated like a sale. The estate ends up acting as the seller. The individual who wants to have the complete interest in the property is the buyer, but usually there is a way for the estate to then perhaps credit that buyer his future interest, an equity interest, so that you're not having having to come up with all of the money to purchase the property.
Right, to come up with the money and then end up getting it right back
exactly.
again. Yep.
So you might just have to come up with your 50% share, because through the estate you're going to inherit 50% and then you're going to buy 50%. So
Right.
That's how that math might work.
So what kind of documentation would we need then at that point? If it was, say it's owned by an estate, what do we need to see to figure out what we're doing?
Well, of course, pursuant to the title standards, when we do a title examination, that also includes a search of the probate records. So we're going to make sure that we're going to do a probate search and determine whether or not that transfer can happen pursuant to consents of all the heirs, whereby the heirs of the estate sign off and allow the transfer to happen to the new buyer. Or alternatively, does the court need to approve something? Do they need to get an actual license to sell? Is that similar in Vermont, Morgan?
It is not.
I fear it was not.
Well, I mean, some similarities. We do have a license to sell, but we always have if it's coming out of the estate and it's not just being decreed to somebody. Probate search is not a normal part of a title search in Vermont, because if it's decreed to the heirs, we just record the decree. And so if it's a scenario like this where it's not just being decreed to both of them, it's still in the estate, one wants to buy it out of the estate, then we would get a license to sell. Any conveyance out of the estate, we get a license to sell. Mm-hmm. And if I'm doing just the real estate transaction, I don't need to see the entire probate estate. I would deal with the probate attorney to see just what I need to see, which is pretty much the license to sell. That is the court saying they're good to go to sell this.
It sounds like there's actually one thing about Vermont that might be a little bit
we have a couple of
easier
things.
and more straightforward than the process is in New Hampshire and Massachusetts. So that's refreshing to hear.
Yes, it is. It is nice that it's all right there in the land records for me.
But I have to add in here a little plug for our counterparts in estate planning and accountants that are so important in these transactions, because you're going to want to go back to perhaps the estate planning attorney or the probate attorney that's handling the estate, because there may be tax consequences that you want to avoid, and you don't want to, let's say, interfere with an estate plan.
Oh, absolutely. And creditors within the estate that you need to make sure, if you're not selling that for fair market value out of the estate, there could be an issue with creditors that need to be dealt with. So you certainly want to talk to your estate planning and probate attorney if you're doing anything like that.
And that's similar to the estate as an owner example is the trust as an owner example, whereby someone could have a beneficial interest in the property, and that may or may not be credited to them at the time of closing. But if the property is owned by a trust, just because you are the trustee or just because you are a beneficiary, that does not identify you as an owner that's going to make it sufficient to be a refinance transaction. We're once again talking about really a sale, aren't we?
Yes, yeah, absolutely. And then, which means transfer tax. So how does the transfer tax work in these scenarios?
So I would say for both the trust and the estate scenarios, we're really talking about basing the transfer tax on the fair market value of the interest being transferred. So when it's the sale transaction, we're of course doing it based on the purchase price of the property, and that's why we typically see the estate or the trust selling for fair market value established by a realtor perhaps or an appraiser, and then the credit of that beneficial interest happening. It makes things a lot less complicated for calculations and reporting to the DRA. Again, that's going to be tempered perhaps by advice from the estate planning attorney or the accountant. When we're talking about the straightforward ownership interest where, let's say, two siblings own 50% of the property and only 50% of the property is being transferred to the end owner, that's going to be based on the fair market value again of what's being transferred, and that's going to be the 50% interest. And so that's how ultimately we'll calculate 1/2 in that example of the fair market value and establish the transfer tax to be paid.
So if people are doing a buyout refinance within a trust where one of the beneficiaries wants to buy the rest of the interest out of the trust, what kind of documentation do we need? Is it the same as if we're doing a refinance or a sale out of a trust like we discussed in our previous episode?
Absolutely. So we may need to see a copy of the trust or that certification of trust. We're going to need a trustee certificate, as we would always need when a trust is involved in a refinance or a sale transaction. And I'll just add here that many trusts actually have conditions under which documents can be signed. So a trust, the terms of the trust might actually indicate that beneficiaries actually have to consent to certain actions. So make sure that you understand your trust well before you try to refinance or sell, of course.
Excellent. And then, of course, another one that we get commonly is now it really is vested in two or more people. It's not in the estate anymore. It's not in the trust. It's two people that own property together, and somebody wants to quote unquote come off of title in the process of a refinance. What do we need to know there?
Very important to know is whether or not there's actually already an active mortgage on the property, because that could very much impact if it's a refinance and that loan is being paid off, then that's no problem at all. The loan gets paid off, the individual gets bought out, the transfer tax is paid like we discussed. However, if this is just someone wants to come off title but they're not in the midst of a refinance transaction or a sale, then you're starting to worry about, is that individual on the existing note? Are they on the mortgage? Are they looking to come off? And are they looking for any money in that transaction? So I would say it's very important to know, whether your lender is going to require modification of the existing documents that are already there and on record.
And what about transfer tax there? Does that just turn on whether or not money is changing hands?
I would say that it is a very important point to determine whether or not there is any money changing hands. Certainly, somebody could come off of title and not ultimately get any money, and it would then be a consideration of, is this truly a gift? Is there consideration in the form of just by virtue of the person coming off of the note and the mortgage that's actually consideration for the action taking place? So it's not necessarily that someone might get a check at the end of the day, but ultimately, if there's some value
that makes sense
in exchange for coming off title.
And in Vermont, we're very different on that one, that it has to do with really the relationship between the people. They more or less, they'll need some sort of family relationship, father, daughter, parent, child, grandparent, grandchild, or married. Yeah, and so the common one that we get of people who were not married that bought property together, that's not exempt from transfer tax, even if no money is changing hands. So definitely good to talk to somebody in advance to know what you're doing.
And of course, the main exception to that is transfers that are being made pursuant to a divorce decree.
Correct.
So in New Hampshire, there is the statutory exemption that if a transfer is being made pursuant to a final decree of divorce, there is no transfer tax due. And that's regardless of whether any money is changing hands.
That's true in Vermont as well.
And what people will need to be prepared to provide, we will actually need to see the final decree. And do you think that it's appropriate that if we see certain portions of the final decree, Morgan, that's sufficient, or do you feel that you need to see the whole decree?
I feel I need to see enough of it to know that it is final. I also need to see it. I want to know, do you have a divorce attorney that I should be talking to as you're a represented party in this? So I want to see enough to see, do you have representation, and is this actually final? Because it makes a difference as to whether or not it is actually final.
And there are also many times conditions in the final decree of divorce that it lays out that the property needs to be transferred within a certain time period for a certain amount of money. And ultimately, those provisions are going to control.
Absolutely.
Ladies, thank you for joining us today. It's really interesting to talk about how you can buy out a co-owner or a joint owner of property, and we appreciate you reviewing the details with us. Thank you.
Thanks for having us.